This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
What is a public interest litigation? And another part is, in a public interest litigation, how much facts and the evidence are required to be given? Is it 100%? Like a civil trial or criminal trial? My lord, the public interest litigation, as your lordship knows, my lord, I am not required to give the background. It was evolved by the court, Supreme Court, by nature. Supreme Court has felt it right from Justice Bhagavati's judgment, P.N. Bhagavati, that yes, time has come up that the public interest litigation should be there. A seared case is there. A seared case, no details were there. 1982. But in a public interest litigation, may I just submit to a lordship, it is not an adversarial system of litigation. It is rather if a grievances is brought, rather in a public interest litigation, the grievance, any cause of action is brought. My submission would be, my lord, it is the duty of the court to look into that grievance. Yes, there is a genuine grievance exist or not exist. And in that case, the court will not go by technicalities. This pleading is not there, that pleading is not there, it's not a civil court. That is, after that, what has happened? After the police officer has come, who is the police officer? Whether he turned into right side or whether he turned into the left side, no. In a police overt action even, lordships have not questioned who is the police officer has come. It is otherwise a police overt action. Who is that particular police officer has come, at what time he has come, what he was wearing, whether he has come by bus or whether he has carrying on the motorcycle. Grievance is that whether the police officer has come. Grievance is that the meeting has been held in a town outpost, not in the police station. It has been stated in a town outpost, and your lordship knows what is a town outpost. In Bengali, which we say is a phadi. This petition, my lord, your lordships have said why the imam has not come, correct? Kindly see your lordship's rules. Rule 20. My lord, your lordships are issued a notification on 23rd August 2016, defines public interest litigation. Can I just hand it over this judgment? Your lordships have quoted that my lord's judgment, Justice Nishita Matre and Justice Chakraborty. Let me see. What is the definition of a public interest litigation? See, my lord, paragraph, yes, citation is, I will rely later on, 2017 SCC Online Calcutta 899. Brojes Jha versus Union of India and others. See, my lord, on paragraph 14.
Paragraph
14. The notification issued on 23rd August 2016 defines public interest litigation as follows. But it is in the incorporated in the rule. Rule is not with me.
Mr. Bandhu, the paragraph 14.
14, my lord.
Oh, the quoted portion. Yes.
Yes. It is quoted. The rule has been quoted. Public interest litigation shall include a litigation, the subject matter of which is a legal wrong or legal injury caused to a person or to determinate class of persons. Paragraph 14.
This is page.
Now, my lord, can I read again? Public interest litigation shall include a litigation, the subject matter of which is a legal wrong or a legal injury caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, or any burden imposed in contravention of any constitutional or legal provision or without any authority of law, or any such legal injury or illegal burden is threatened, and such person or determined class of person is by reason of poverty, helplessness or disability or socially or economically disadvantaged position unable to approach the court for relief and for redressal of which any member of the public not having any personal interest. Repeated submissions have been made why the imams have not come. Repeated submission why the imams have not come. If the imam comes, then it doesn't remain within the realm of a public interest litigation. If any one of the Muslim community comes with a complaint that, my lord, because of the non-using of the loudspeaker, I can hear the azan, then it's not a remain within the public interest litigation. Personal injury.
Yes.
Therefore, why the imam has not come, who attended the meeting, they have not come, that's not the point. My lord, question is whether the police overt action has infringed the right. That is the question. Infringe the right or not? That, of course, is a constitutional question, not the civil question, law questions. If the parameter of a public interest litigation and the civil suit is same, then why do you take public interest litigation? Tell them that go and file a civil suit. Who has come, who has not come, who will come? The question is, my lord, with great respect I submit to your lordship, whether a skeleton facts have been given. Not the full proof facts like a civil suit.
Yes.
Now, my lord, can I read just this? Social economy for which any member of the public not having any personal interest in subject matter presents an application for an appropriate direction order read of this code under Article 226. Notwithstanding anything in any appropriate case, though the petitioner might have moved a court in his private interest and for redressal of public grievances, the court in furtherance of the public involved between may treat the subject of litigation in the interest of justice as a public interest litigation. Now, my lord, what are the allegations? My lord, what are the submissions? Commission is, first submission is, this is a verbal instructions. I have said, I have written in this, both in the complaint. My lord, today also, the kindly see, no answer has been given to this letter 129, 5th August 2026, District Magistrate Hooghly. Can I read it again, my lord? Kindly excuse me.
You have read it.
Read it. Now, whether any reply has come, no. Although the learned Advocate General has said that no such has been given. And as per the law of the Supreme Court, Advocate General is a part of the government. Supreme Court has said, the Advocate General is a part of the government. That then the government is saying no verbal order has come. But when I have written this letter 129, whether any answer has come from the district, no, this is incorrect.
Yes.
I will give the reply, all the questions. Thereafter, I will make another submission after meeting the whatever the points have been given and whatever the case laws have been given. Now, therefore, this is 129. My lord, I am not, my lord, I have already, Mr. Advocate General also have read today in the morning, paragraph 4, 5, all have read. I am not reading. Therefore, whether any case has been made out at paragraph 4 or not.
Yes.
Leave aside paragraph 5 and 6. This is the grievance, this is the legal point, this is the legal injury. Now, my lord, paragraph 5, I have said the meetings were attended and that has also reflected in the letter. Now said that there is, kindly see the cause title. Police officer's name is not there, kindly come to the cause title. Kindly come to the cause title. Page 2. Kindly take paragraph 5, respondent number 5, the Commissioner of Police, Chandanagar Police Commissioner. Then 6, the officer in charge, Lisa Police Station. Then C7, the officer in charge, Srirampur Police Station. Then C8, the officer in charge, Bhadreshwar Police Station. That is not correct that I have not given the designation. There were at least 4 officers' names I have given it. Although the question raises all over West Bengal. At least this has been given. Now, my lord, I have pointed out to your lordships this. Kindly come to, very importantly, kindly come to paragraph 16, page 10. Now, paragraph 16, page 10. The petitioner has reliably come to learn that the aforesaid verbal deletion and coercive measures being undertaken by the respondent police officials are not isolated to the district of Huskia, but are enforced indiscriminately across the entire state of West Bengal. Multiple credible sources and reports indicate that throughout the state, police authorities are compelling numerous temples, mosques, and possibly other places of worship to remove the loudspeaker forthwith. These officials' actions are being carried out in a summary and arbitrary manner without any preliminary determination. Can you see? Without any preliminary determination as to whether the use of such loudspeaker has actually resulted in any transgression of the permissible sound limit or not. But my point is very short. I am entitled to use the loudspeaker within the permissible limit. No qualified personnel have been deputed to measure or assess the decibel level of sound emitted from such devices. How the police can do it? This is the aberrament. Then, Millard, nor has any ascertainment been made by the competent authorities to determine any concrete infraction of the existing rules, notifications, or the circular dated 17th October 2023. I have submitted, again I am resubmitting that an unique procedure in the state now. No, it will said on the verbally, do it, no public notice, no public domain, nothing, and police will go and implement. This is my submission. Earlier also in one case I said so. Again I am in this case. Again I am doing it in one case before Justice Sampar Sarkar. A new practice has been born now, developed.
Yes.
Now, Millard, this is, your lordship has seen, this is regarding this. I will not take much time on that. Now, let me tell your lordship the case laws, the judgments which have been cited, and I will cite. The first which I hope, Millard, what is my case about? I have said police has gone, threatened, you remove it. That I have said in the paragraph 5. and paragraph 8. Can I read it again? Not necessary.
Read it. Read
I have read it. This is the. I will show. If your lordships permit, I will show one document. Police has gone and seized after the meeting of the case laws, because that it was not there. It is 2009-15. Na? Well, 2009, volume 15, SCC, page 351. I have not much judgment. Paragraph. Kindly come to paragraph 33.
Paragraph
33. Even my lord, in a case, kindly excuse me, even in cases, forget about this, my lord, pleading and etc. Any person has come approached to your lordships or not. Even your lordships, after reading a newspaper, can so much initiate the public interest litigation. This has been done here. Then at that time, whether it was an admissible evidence or not, whether complete facts and figures have not been given or not, only one, sorry, my lord, I am before that, just excuse me, well, just excuse me. One page I could not show to your lordship, so I am coming. Just one page. Kindly excuse me. That is the page, my lord, that he has read it. Again, I am reading in my own way. That is, my lord, page 137. This is 138.7. Caption, leave aside caption. Caption is the creature of editor. The West Bengal police has asked mosques in various parts of the state to limit and remove the high decibel loudspeaker at the top and replace them with sound boxes. And sound boxes, I have already, my lord, cited the judgment of the Supreme Court on the other day. There's a direction that all manufacturers should manufacture the loudspeaker with the limited sound which has been given. The question is today whether the state of West Bengal that has been implemented. Can you remember? I will show that judgment again. That following the police request, various mosques in the district of Bengal removed loudspeaker. Next. The more following a decision taken by the newly elected so-and-so in his first cabinet meeting, the nominal second, police held meeting with the mosque committee. Therefore, today it is said no meeting has been done. That's also not correct. Police has held meeting with mosque committees in several days over the few days. According to those involved, committees were asked to replace rooftop loudspeaker with sound boxes. Urban development, so-and-so, so-and-so, so-and-so. Now, my lord, kindly come to next middle. However, some Muslim organizations question the manner of implementation. It is two parts. I am no manner of implementation.
However, where you are reading?
However, some Muslim organization, middle,
Page.
must read, then 138 middle.
Which paragraph? Oh, however, that's. Yes.
However, some Muslim organization question the manner of implementation. Nijamuddin Bishwas, General Secretary of All Bengal Imam and Mujira Association, told the Indian Express that mosque committees were complying with police requests but argued that enforcement should be based on measures noise levels. The police approached mosque committee, asked them to remove the loudspeaker. So many are doing so, but there should be a proper system to measure decibel levels at both mosques and temples. If the sound exceeds this permission, it should be reduced. The law prescribes noise. It does not say loudspeaker must be removed altogether. That is not the one part of the report. Other part of the report would be also when they have placed it. Siddiqullah Chaudhary, the petitioner, the president of the West Bengal, the honest to answer, the court have put in sound limits. Nowhere it is written that mosques will have to remove mics. We will oppose this move by the police.
Very good, Mr. Bandhavata. This is there in our. You have answered that.
Pardon?
You have answered that. You
No,
said that
what I am saying, my learned friend has read the one portion of the report, but
Yes,
other
yes.
portions of the report has to be taken care,
Yes.
which is not done. That's my case. That is exactly my case is. Now question is, my lord, this is the statement. My lord, one thing is vague statement. Another thing is 100% proof statement.
So that you have argued, the grievance has to be concerned.
Yes,
Technically,
I'm
it cannot be gone.
I am so grateful to you, lords. I am so grateful to you.
You have taken.
I'm very sorry, my lord. I'm so grateful. Now, my lord, kindly see this judgment which I was reading. Kindly, my lord, take this. 2009, volume 15, SCC, page 351.
Yes.
Paragraph 33.
Paragraph 33. In a public interest litigation of this nature, it is not necessary for the court to abide by the strict rules of pleadings. And even it is found that the petitioners are busybodies, the court will discharging them could proceed to deal with the public interest litigation suo motu. In Nirmal Singh Khalun versus State of Punjab, this court held the High Court, while entertaining the writ petition, formed a prima facie opinion as regards the systematic commission of fraud. While dismissing the writ petition filed by the selected candidates, it initiated suo motu public interest. It was entitled to do so. The nature of jurisdiction exercised by the High Court, as is well known, in a private interest litigation and in a public is different. Whereas in the latter is inquisitorial in nature, in the former it is adversarial. In a public interest, the court need not strictly follow the ordinary procedure. It may not only appoint committees but also issue directions, so and so, so and so. That's not it. This is therefore, this is blood the Justice S.B. Sinha, the Supreme Court judgment. Next, my lord. আমাকে আগে ইয়েটা দাও এর আগে চিফ জাস্টিস they have cited the Bharat Singh's case. They have cited. That is 2000, 1990, 88-4. Kindly take this one. This is 2023 one High Court cases, Calcutta 484. 2023 SCC online, Calcutta 1496. Suvendu Adhikari and another versus State of West Bengal. Suvendu Adhikari at that point of time was the opposition leader.
Yes.
And number 2 was a lawyer. Mr. Torun Jatutiari in this case.
Yes.
Now kindly come to paragraph 16. Can I read, Mr.?
Yes.
But Mr. Urunpukar's strategy used to say, Mr. Bandyopadhyay, paragraph 16.
Yes.
With regard to the submission of Mr. Bandyopadhyay that the pleadings are vague, no evidence has been placed on record. Court cannot decide or on media trial. Court cannot decide based upon oral submissions of advocates across the bar, etc. Have been noted by this court, but what is important to point out is that the present writ petition is a public interest litigation. The Supreme Court in Narmada Bachao Andolan case has held that strict rules of pleadings may not apply in PIL. However, there must be sufficient material in the petition on the basis of which the court may proceed. The PIL litigant has to lay a factual foundation for his averment on the basis of which such a person claims relief. The information furnished by him and should not be vague and indefinite. Proper pleadings are necessary to meet the requirements of the principles of natural justice. Even in PIL, The litigant cannot approach the court to have a fishing inquiry or roving inquiry. He cannot claim to have a chance to establish his claim. It was further pointed out that the technicality of the rules of pleadings cannot be made applicable vigorously. Pleadings prepared by a layman must be construed generously as he lacks the standards of accuracy and precision, particularly when legal wrong is caused to a determined class. The present public litigation is sequel to the earlier set of public interest litigation which were disposed of by common order date 13 June 2020.
Yes, Mr. Bandhu, that we understood. Your grievance we understood.
Kindly read this, Milord. Bharat Singh has been considered there. Kindly see that. Just kindly give me, Milord. We find that in the public seeks to focus on the consequences which have been occurred on account of non-compliance of the directions issued in the earlier order. Similar, same nature of cases is mine. And therefore, in our view, the court is well justified in entertaining the public and considering the matter in a wholesome perspective. So far as the decision of Bharat Singh case, which I cited that day, today they have cited now. Now, Bharat Singh case is kind of this same would be inapplicable to the facts and circumstances. It was a writ petition challenging the validity of an acquisition on the petitioner's property by the state of Haryana under the Land Acquisition Act 1894 in the said case. An allegation was made that the application made by the Haryana State Industrial Developer is nothing but a so and so. The judge has been distinguished completely on facts. And it has said, and here in this case, who was that? Then opposition leader, responsible person.
Yes.
And one of the writ petition, one of the advocate. Even then, our High Court has said no. No break pleading. And continuation of the directions. Here also I am asking for the directions which were there. I am not asking anything new thing from your lordships. What I am asking, I am saying the strict compliance of that directions. And no one can interfere so long I follow the directions. If I don't follow, file individual cases, that will be sin. Nothing more than that. Now, Milord, next is yes, this judgment I have given to handed over in the morning for quotation. 2017 SCC online Calcutta 899. First to check. This is Matre. Now, Milord, kindly see of that judgment.
Oh, 2007, 17
Yes,
SCC,
in the morning.
Calcutta 89. Yes.
Kindly see, Milord, I am not required to cite so many judgments because after paragraph 14, the Milord, your lordships have dealt with so many cases, right from Janta Dal, etc., one after another cases. I am not required to, Milord, I am just to make it short, I am doing.
Yes.
To paragraph 22. Just a minute. 21. 21, I have 21. So 21, kindly come to 21. After considering the, can I read? After considering the aforesaid judgments, in my opinion, it cannot be said that the petitioners have no locus stay to file the present. Moreover, it is now well settled that when the interest of the public is the foremost consideration, for filing a writ petition, the courts will normally entertain it. However, the courts would consider whether such a petition has been filed with an ulterior motive or with an aim to embarrass the persons against whom the writ petition has been filed only for a private reason. There is no private reason because the petitioner is motivated by consideration other than for bringing to the issue so and so, so and so. Now, then paragraph 22. The argument of Mr. Bandyopadhyay that the petition is not maintainable because there are neither so and so in the nor has a cause of action has been fails to impress me. In DLF housing construction and Delhi so and so, the Supreme observed that it was hazardous to embark upon the determination of the points involved in writ petition. There may be a firm and adequate. Mr. Datta has argued that no research was done so and so. Now, all have been rejected. That's arguments. Then, Milord, kindly come. Kindly come to paragraph 70. 79, paragraph 79. Article 226 of the Constitution of India is couched in a wide language so that the authority of the writ court is not confined only to issue prerogative writs. Such wide language is used to enable the writ court to reach injustice wherever it is found. The jurisdiction on Article 2 of the Constitution is expensive and extraordinary, and the same does not stand fettered to answer. Next, paragraph 80 is important. The expression public interest means a legal action, which is in it. This part was written by my Lord Justice Chakraborty. There are two parts are there of this judgment. This means a legal action which is initiated before the court of law for the purpose of enforcement of general interest of public. The technical misdescriptions and deficiencies in the setting out of the case title or to be secret open to non-suit a party.
Yes.
Where foul play is absent and fairness is not faulted, latitude is a grace of processual justice. This is all my Lord Justice Chakraborty has said in this judgment. And here is in this case also Borges Jad, he was also lawyer.
Yes.
Next, Millard, now I have to distinguish all these judgments. Now I am just first, I will not take much time, kindly take it, Millard. First judgment which has been cited by him, 1984 Calcutta 52. Just take note, Millard. Not required at all, Millard. Yes. (1984) Calcutta.
Yes.
My Lord Justice Chakraborty raised, my Lord Acting Chief Justice has raised the question whether this judgment is a public interest litigation or not. See, this is a mandamus appeal. This judgment in a mandamus appeal, not in a public interest litigation. And by the unsuccessful candidates challenging the selection process. Therefore, this judgment has no application. Then, my Lord, kindly come to judgment 1983 Calcutta 131 ki chilo? Oh, same. Achha, okay. Now 2016 SCC on 2026 SCC Calcutta 1086. But let me just, I will make it very, your lordships will understand what I want to say, where I am trying to distinguish. One judgment is sufficient. That's a 2010 3 SCC 402, which has been cited by them. Kindly see this judgment. Factually see. 2010, the judgment has been cited. 10 3 SCC 402. Kindly come. Read this paragraph first. 402, kindly come to paragraph. 173. 174 is first.
এখানে দেয়নি এই বইটা নিতে হবে।
First read kindly 20. In the instant case, one of the petitioners before the High Court, can I read? Copy actually down, Judge Sahib.
20, paragraph 20.
Oh.
Yes.
See, in the instant case, one of the petitioner before the High Court is a practicing lawyer of the court. He has invoked the extraordinary of the High Court in this matter. It was expected from an honorable member of the Nobel Prize not to invoke the use of the court in a matter where the controversy itself is no longer res intriga. This was a question regarding the office of the Advocate General. There should not be more than 62, no? More than 62. And in UP, the Allahabad High Court earlier decided the points, Supreme Court has decided the point, no. This is not applicable in case of the Advocate General. Now let's see, to invoke of this court in a matter where the controversy itself is no longer is. Similarly, it is a bounden duty of the court to ensure the controversy once settled by an authoritative judgment should not be reopened unless there are extraordinary reasons for doing so. Now, but here my case is, once the point has been decided by this court, how a police can, by an overt action, can nullify the judgment.
Yes.
Then, Millard, 21. The High Court entertained the petition despite the fact that the controversy involved in it was no longer syndicated. This is a representative chief standing counsel. Then, Millard, this is the main position. Kindly come to paragraph. We can't chula. Kindly, 173. Kindly come to Millard 173. I am making it very short.
Yes.
When we revert to the facts of the present case, that the conclusion is obvious that this case is a classic case of the abuse of the process of the court. In the present case, a practicing lawyer has deliberately abused the process of in that process. He has made a serious attempt to demean an important constitutional office. The petitioner ought to have known that the controversy which he has been raising in this petition stands concluded half a century ago by a division bench judgment of the Nagpur High Court. Therefore said, no, lawyers should not come with this.
Yes.
Factually, Millard, it is so distinguishable. And so far, Millard, paragraph 181 is concerned, there is no cold. The question is this, Millard, the court should prima facie verify the credentials of the petitioner before entertainment. Credentials is there. This petitioner has also filed 3 other writ petitions, PIL, earlier, which this court has entertained it. I have given the details of that. And another paragraph, prima facie regarding the correctness of the contents of the petitioner before entertaining. Therefore, the correctness today before a lordship's court, the main question is coming, whether, first of all, is it really vague? Absolutely nothing is there. Or 100% proof statements have not been given.
Yes.
But in that case, what the court should follow, the procedure, I have given the judgments. And again, I am repeating, Millard, this is a greater interest. Millard, this is my submission. But today, I will be seeking to file a supplementary affidavit, giving few details.
We have heard you, Mr. Bandhu.
I understand. I am giving.
Then you are bringing in a supplementary evidence. We are determining.
If your lordship decides today, finally, naturally, the supplementary affidavit will not be used. I am saying that if
Mr. Bandhu, we are under the impression we are hearing out.
no, I have no objection.
No, you,
I have no objection. But the queries which were there on the other day from your lordship, all these queries are answered in my supplementary affidavit.
no,
Police went there, seized.
new material comes in, Mr. Bandhu, then we have to again give it copy to them, then decide.
All right.
That is your choice. If you say that at this stage you want to use a supplementary evidence, then it will be decided.
Yes. With a smiling face.
No,
I understand. I am saying, if your lordship finally decides the matter, I am not filing. That I have said so.
yes, Mr. Bandhu, we are deciding the
Very
matter.
nice. No problem. I have no problem. I am not filing it.
Yes.
I have concluded my argument.
Ah,
But there are only one thing. There are number of judgments have been cited by them. If I take one after another, then it will take long time. There are 12 judgments have been cited.
no, you have.
But I am submitting there that all are factually completely different. In Madhya Pradesh, there is no ratio. Bharat Singh case has already been considered and distinguished by my Lord Chief Justice Sivagnana. Third one, that the judgment, this is what Allahabad judgment, no ratio. Others Calcutta High Court judgments also distinguishable.
Thank you. We pass our orders. 2 p.m.
2 minutes.
Again,
Reply
Mr.
against reply.
No, the cases. The 1983 decision, my lord, which I cited, the division bench judgment,
Mhm.
it's, my lord, it was submitted that it's FMAT. Now, my lord, possibly, my lord, in
No,
1980.
Mr. Bandyopadhyay said about 1984.
84.
No.
2000.
84 Calcutta.
84 Calcutta, yes, sorry. 84 Calcutta, my lord, it is submitted that, my lord, it is FMAT, so it was not a public interest litigation. My lord, I had placed this part, paragraph 18. May I read out only one line? It is, however, contended by the learned advocate appearing on behalf of the writ petitioners that as it is a public interest litigation. Paragraph 18.
Yes, that is why I was asking my brother. Then this is a mandamus appeal.
At that point of time, this demarcation possibly in 83,
Oh, 83. No.
this demarcation was not there. It was not marked as, my lord, PIL or P. These markings were not there.
All right. We pass our orders at
It
2
was written mandamus appeals. Just read it.
That is true.
Mandamus appeals.
All right.
Yes.
The matter has been fixed, my lord. I have to argue my next week, my lord, you will also going to ratify. Other side is here.
Let us pass the order. 3 o'clock, I have a bench. And I never dismiss matters in the absence of the advocate.